الحمد لله نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلل فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدًا عبده ورسوله صلى الله عليه وعلى آله وأصحابه ومن تمسك بسنته إلى يوم الدين أما بعد. So as we continue discussing the book Al-Mulakis Al-Fiqhi by Sheikh Salih Fawzan Hafidullah Ta'ala, and discussing matter that relates to mawarith, matter that relates to inheritance, and discussing concerning of those masahil that's also attached to this discussion regarding certain cases regarding that different individuals or group of individuals regarding what's their take regarding al-mirath. So he mentioned in this particular case matters regarding the closing chapters of mirath, mutallaqa, that the lady are the one who's divorced. So discuss concerning a divorced woman, what's the ahkam regarding her and inheritance. Aywa.
Bismillah wa salatu wa salam ala Rasulillahi qala ma'alif hafidahullah, chapter 23, page 335, title Inheritance of Divorced Women. Verily Allah, exalted be He, made the marriage contract a cause for inheritance. Allah Almighty and ever majestic be He says, and for you is half of what your wives leave if they have no child. But if they have a child, for you is 1/4 of what they leave after any bequests they may have made or debt. And for them, i.e. the wives, is 1/4 if you leave no child. But if you leave a child, for them is 1/8 of what you leave after any bequest you may have made or debt. Surah An-Nisa, ayat 12. In consideration to this, the two spouses inherit from each other as long as the marriage contract has been valid until the death of the inherited spouse, unless there is a cause that prevents one of them from inheriting from the other. However, no inheritance is to take place in case of the irrevocable divorce, for the rule of thumb states that if there is no cause, there is no effect. However, there might be some conditions in which divorce does not prevent the two spouses from inheriting one another. To illustrate, the two spouses inherit from one another in case of the irrevocable divorce as long as the wife is still in the waiting period. Muslim scholars have singled out a specific section for the inheritance of divorced women. Regarding this, divorced women are the 3 types.
So here the author, Hafidullah, discussing regarding concerning of the ahkam of al-mirath or fara'id, of those cases that relates to a divorcee, so a lady been divorced. So in this case, that he will start to go into some detail regarding that a case concerning al-talaq al-ba'in, where they're completely divorced and separated. They're not per se in a contract of a marriage anymore. They're completely there. Then there's no inheritance. But in the case that they discuss certain cases or certain cases where she may inherit or not inherit depending on certain circumstance. So he mentioned those cases where she may inherit, or those cases that she inherits, and cases that she does not inherit based upon certain factors.
First type, a revocable divorced woman. No matter the divorce has occurred while the husband is still in good health or not.
So that's concerned. The first that they mentioned, al-mutallaqa al-raj'iyya. So al-talaqa al-raj'iyya, al-mutallaqa al-raj'iyya is a case where a female been divorced, but she's still in her iddah. So she's still technically married, she hasn't completed her iddah, so she's still, even though the divorce have been said or pronounced upon her, but during, so she will go to an iddah. So that iddah would last either for 3 months or for 3 menstrual cycle. So during that time, the husband she can be returned back to the husband. She can be returned back to the husband. So they're referred to as a talaq al-raj'i. So she's still technically married to her husband. Aywa, so they can be alone, they can still sleep so they can still function as husband and wife, but they're just going through a talaq until he takes her back. Aywa.
Second type, a woman irrevocably divorced while her husband is in good health.
Ayda for talaq al-ba'in, so we'll discuss, and that will be discussed regarding al-ba'in, that you have al-sugra wal-kubra. So al-talaq al-ba'in, that will be that they're somewhat separate. It could be a sugra or kubra. So as-sughra, that a case where a man divorces his wife, and it's a first divorce, and she have finished her iddah, and they have gone separate ways. Now, if she still hasn't to remarry, he can remarry her without her remarrying someone else. Clear? So that's concerning al-talaq al-ba'in as-sughra. So he divorced her, so they got married years back, they had children, he divorced her 6 months ago. She ended her iddah, he didn't take her back, that's their first divorce, but they have gone separate ways. She hasn't, then he chooses to remarry her. So that can still take place without her remarrying someone else, because only one talaq have gone between them. So that's concerning al-talaq al-ba'in as-sughra. Aywa.
Third type, a woman irrevocably divorced while her husband is in his last illness.
A marad al-maut, like in the times of
Yeah, like he's passing. Go on.
Aywa.
Yeah. Concerning the legal ruling of each of the above cases, the revocable divorced woman is unanimously agreed to be entitled to inherit once her husband dies, as long as she is still in her waiting period.
So regarding those cases, he mentioned the first one, so he explained the three circumstances or different circumstances regarding a talaq between a husband and a wife. So as for the first case, more so regarding how the impact on the wife. So in the first case of talaq al-raj'i, because they're still technically said to be married, even though they are going through a divorce, but haven't per se, the divorce haven't been finalized or come to an end, so they're still technically married. So in those cases, that she's entitled she's entitled to inheritance, she's entitled to be inherit. And he mentioned there's an ijma between the ulama, as mentioned by Ibn Munzir, that is an ijma regarding that she's entitled to inherit from her husband. Aywa, that's the first case.
This is because she is still regarded as a wife and she is entitled to all the rights a wife has.
So we'll discuss some of those matters more in matters concerning ahkam, talaq and the likes, but generally that what is mentioned here, she is still considered to be technically his wife and still have certain rights, and of those rights she's entitled to is a part of it inheritance if he was to die. Aywa.
It is also unanimously agreed by scholars that the irrevocably divorced woman, while her husband is in good health or suffers from a curable disease, i.e. is not seriously ill, and not being suspected to have disinherited his wife, i.e. by divorcing her, is not entitled to inherit from her husband, for she is no longer related to him.
So that's the second case, that's the second scenario regarding that. They are divorced, completed the iddah, he did not take her back and they went back together, and now they're living separate life. They are now considered to be divorcee. Both of them are not together. She can marry whoever she wants. He can marry whoever he wants. Then in that case also, she does not inherit from him because the iddah period have come to an end. The iddah have come to an end and they did not per se reconcile or went back together. So in that scenario, then she's not she does not inherit from him as he's not responsible for her. Aywa.
Likewise, the irrevocably divorced woman whose husband is incurably ill and he is not suspected to have disinherited his wife, i.e. by divorcing her, is not entitled to inherit from him.
Aywa.
In contrast to the previous case, the irrevocably divorced woman, while her husband is in his last illness, is entitled to inherit from him during the waiting period and after it ends, provided that the husband is suspected to have intentionally disinherited her by divorcing her, and that she has neither remarried or apostated after the divorce.
So another scenario regarding that, a man divorced his wife, in a time that, during his illness, and his intention behind it was kind of somewhat to cut her off from his inheritance. So he wanted to cut her off. So he divorced her so as not for her to inherit. Then in that case, as mentioned, that there's some tuhma, there's some his intention wasn't per se valid, or that his intention was somewhat corrupt regarding what he did. So in that case, that she can inherit from him. She still, in that case, can inherit from him. Aywa.
This view is asserted by the incident when Khalif Uthman radiallahu anhum judged that the wife of Abdurrahman ibn Auf, may Allah be pleased with him, whom he irrevocably divorced in his last illness to disinherit her, had the right to restrict, had, hold on a minute, had the right to inherit from him, i.e. Abdurrahman ibn Auf. This judgment, which is not restricted to the waiting period, was known among the Prophet's companions and none disapproved of it, despite a rule of the avoidance of disputes and sins. This is because such an ill-intentioned husband is treated according to his bad intent, i.e. his intentional divorce of his wife in his last illness to disinherit her, and Allah knows best.
So as a second case regarding that, he mentioned that in this scenario regarding, as the Shaykh Hafidullah, he mentioned that a person was have ill intent. So the husband have ill intent that he wanted to cut his wife off from any inheritance, so he divorced her so as to for her not to inherit from him. So in that case, if the matter is placed to the qadi or to the judge, then the judge can rule against this. The judge can allow her to inherit because of the ill intent by way of the person's action and the circumstance, that the judge can rule that she's allowed to inherit from him even if the iddah have come to an end. So she went through her iddah and it came to an end. She's somewhat completely separate from him, but because of his intent, then when he did that act was ill-intended, then the judge can rule that she receive her portion as being the wife. That's after the June, that can occur at any point, as long as she hasn't per se remarried. She hasn't remarried. Aywa.
Moreover, the two spouses inherit from each other by virtue of the marriage contract if either of them dies before the consummation of the marriage or meeting in privacy due to the generality of the verse, and for you is half of what your wives leave if they have no child. But if they have a child, for you is 1/4 of what they leave, after any bequests they have made or debt. And for them, i.e. the wives, is 1/4 also.
So of the next matter they discuss regarding concerning that husband and wife, that in general they inherit from each other, but at what point? So regarding, because I mentioned regarding that idha mata, so if one of them were to die, and it's a case where that, as we'll discuss more in the bab of an-nikah, that when they get married, concerning that when they're considered to be, she can inherit or they can inherit from each other, and certain ahkam applies to them. So before him having intimacy, they mentioned qabla dukhul, meaning that before intimacy. So if the husband was a man was to marry a lady, there was no intimacy, and then he died. Is she allowed to inherit from him? So they got married, a legitimate marriage. They did not consummate, but then he died before consummation. Is she allowed to inherit, or is she entitled to get anything from his inheritance? So from what the Shaykh mentioned, qabla dukhul, so even before, so in this case, she's allowed to inherit from him. So if they were to get married, there was no consummation, they were married for a couple of weeks, but they didn't, but he and her at the khalwa, they were in privacy, but in per se have intimacy. Then she's allowed to marry based upon what is mentioned, as they mentioned concerning that. وَلَكُمْ نِصْفُ مَا تَرَكَ أَزْوَاجُكُمْ. So it mentioned أَزْوَاجُكُمْ in general without putting any type of criteria to it, whether before they have intimacy or after intimacy. Aywa.
This is because the matrimonial relationship is an intimate and noble one upon which great rulings and interests are entailed. Therefore, Allah, exalted be He, prescribed for both spouses some share of the estate of one another when the other dies, as Allah did for the relatives. This ensures that both spouses should respect and venerate one another. These are the blessings and gracious rulings of Islam, to which we supplicate to Allah to keep us strictly adhering and embracing it forever.
So that's concerning of those masail that relates to al-mutallaqa, the woman that is divorced, regarding her circumstance where, in cases the ijma between ulama, that she's deserving and entitled to get a portion of the inheritance from her husband, even though a talaq have taken place, or talaq have taken place. So if a talaq al-raj'i, where she's still said to be his wife, she's entitled to inheritance. At talaq al-bahin, where they're separate, then they are not considered to be husband and wife, then she's not allowed entitled to inheritance, but except in a case where the husband he divorced her, or he's accused, or there's some accusation that he may have divorced his wife before his death so as to cut her off or cut her out from getting any of his inheritance. If she allowed, then that matter can go back to the court, and the judge will look into the matter, and at times is a possibility that it could go where that the judge may rule in her favor based upon the circumstance of the case, or may rule outside depending on the circumstance of the cases. But if the husband had ill intent that he wanted to cut her off, then in those cases, if it can be proven, then the judge will rule in her favor of getting a portion of their inheritance. And he mentioned again regarding the next matter regarding that at what point the husband and wife are that the rules where they can inherit from each other, it starts. So from the time that the act of nikah is done, or is it after consummation, or after privacy, then you have mentioned regarding concerns now after the act of nikah, the marriage have taken place, then they are said to be husband and wife, and their rights, the rights between them, now they have rights between themselves, and of those rights, is inheritance. Of those rights is inheritance even before the khul, even before intimacy takes place between both, then she's deserving, or they're deserving to inherit from each other, and is mentioned, Allahu A'lam. So you find that in certain masail regarding al-zawaj, we'll discuss in Babu Nikah, that other things that will be discussed regarding concerning, other things will be discussed more in detail, bi-idhnillahi ta'ala. Aywa.
Bismillah wa salatu wa salam ala rasulillahi qala ma'allif hafidhullah, chapter 24, page 339, title Inheritance Among People of Different Religions.
So another of those masail, we call that another of those masail, they call considered mawana. So of those cases regarding al-mawana, when a person may be blocked from inheriting from a person that normally they inherit from. So of those mawana, of those cases that a person somewhat blocked from inheriting, then of those cases regarding that bab concerning ikhtilaf ad-din. So those cases affect we'll discuss that. So in case of ikhtilaf regarding of their faith, their religion, then that can have an impact regarding you inheriting from the person or not.
By referring to difference in religion, we mean that the inherited person embraces a religion different from that of their heir. This topic includes two issues. First, when a disbeliever inherits from a Muslim and vice versa.
So this matter that is being discussed regarding ikhtilaf ad-din, regarding differences in religion or faith, that mentioned regarding, I will discuss concerning that one. He discussed concerning that ikhtilaf ad-din, you have Islam/Muslim, and you have kufr. So regarding concerning that a difference between Islam or kufr. So kufr is seen as one in opposite to Islam. So even though kufr have different religions within kufr. So within the kufr itself, you have those I will discuss concerning those who are Yahud, those who are Nasara, those who are Majus, those who are Mulhid, those are Ubbad al-Awthan. So within kufr itself, you have different levels regarding kufr. But in general concerning, but in opposite to Islam, they're one. So you have Islam and kufr, with different phases of kufr. Then we have between themselves regarding concerning the kuffar, that regarding them a following of a faith, you have Nasara, Majus, you have Yahud, you have Mulhid, so you have many diyana between themselves. You have many diyana between themselves. So between themselves, then also you have various deen or ways that they follow. So we'll discuss each of those separate. Muslim wal kafir in general, and between the kuffar between themselves. What are the ahkam regarding miras between them? These masail, they somewhat impact. The Sharia put those things in place and discuss those things in detail, but also that it more realistic, it's a matter that affects us in the West, maybe more concerns to us, even though it's a Muslim in Muslim in general. But for those people, especially those who are said to be of those who are reverts, who have accepted Islam, and you might find that in that family unit, you might find maybe a few members are Muslim, maybe one 2, 3, a few members, the minority are Muslim, the majority of the people in that family that they are kuffar. Now, so what can you say? Maybe a family, parents, the sons, the parents may be Muslim and the children are not. So the parents accepted Islam and their children are not Muslim. Or you might find between a husband and a wife. One of the spouse accepted Islam and the other did not. Now you might find the case concerned that the children are upon Islam, but the parents and some of their siblings are not, and other family members. So auto kind of somewhat, so these things kind of somewhat for us in the West, or the Muslim in the West, especially amongst the revert community, then there's somewhat that they have to deal with those situations more so than others. Aywa.
Muslim scholars have entertained 4 different opinions with regard to this issue. The first opinion, the majority of scholars state that...
The opinion regarding concerning, can a Muslim inherit from a non-Muslim? And vice versa. So regardless of the faith of that non-Muslim. So regardless of the faith of that non-Muslim, he is Jew, Christian, Buddhi, he is mulhid. Mulhid, they say this, people have no deen, atheists. Now, so you have those people. So I would say you have Islam or Kufr. So if your family are Buddhist, Christian, Yahud, and whatever, and one of them die, can you inherit from them? And vice versa. Can they inherit from you as a Muslim? So that's the matter that's being discussed. We mentioned aqwal. That is a discussion between the ulama on this matter. Aywa. In some matters.
The majority of scholars state that a Muslim never inherits from a disbeliever, nor does a disbeliever inherit from a Muslim. This is because the Prophet ﷺ says, a Muslim cannot be the heir of a disbeliever, nor can a disbeliever be the heir of a Muslim. Related by Al-Bukhari and Muslim.
So that's concerning Jumhur ulama. That's concerning the matter, but Jumhur of the ulama, so majority of the ulama, of the opinion that a Muslim does not inherit from a non-Muslim and vice versa. You might have a case where the husband is Muslim and the wife is Nasara. So she's a wife, but she's a Nasara. Now, so is there any inheritance between both of them? They have children together, type of thing. So all of those things, so in those cases, but the call of Jumhur of the ulama, majority of the ulama, that in that case, that there's no inheritance between both. It doesn't go both ways, whether from the Muslim to the Kafir, nor the Kafir to the Muslim. Aywa.
Second opinion, the Muslim one never inherits from the disbeliever and vice versa, except through the wala. According to the hadith that reads, a Muslim cannot be the heir of a Christian except when the Christian person is the Muslim slave or his slave girl.
That athar or that hadith is said to be mawquf. So that hadith is said to be mawquf on Jabir, that actually go back to Jabir, the Sahabi. So it's not per se hadith of the Prophet ﷺ, but more so a statement of the Sahabi. Aywa.
This hadith signifies that the Muslim heir inherits from his Christian manumitted slave and vice versa, according to analogical deduction.
So it's based upon wala, as we discussed, of the ways of inheritance by way of wala. So if you have a person who you have released, then you can inherit from them. So this is based upon wala, not based upon family, blood relations.
The third opinion, the disbeliever inherits from his Muslim relative if the former converts to Islam before the estate of the Muslim deceased is divided. This is according to the hadith. An estate which was divided in the pre-Islamic period of ignorance, the Sharia, may follow the division in force then, but any estate in Islamic times must follow the division laid out by Islam.
And that which is concerned that hadith is mentioned, of Ibn Abbas, that hadith of Ibn Abbas regarding the third opinion. So the third opinion of the ulama take the position regarding that in cases that a person was a kafir and they have a Muslim relative, so the parents are Muslim and they have children, the children are non-Muslim, kuffar, and that parent die before the inheritance is divided, that child, some of the children accept Islam. So in that case, they can receive their portion of the inheritance because they accepted Islam before the inheritance was distributed. So that's the third opinion. So of the ulama who take that opinion that in that case, in that scenario, they can inherit. Aywa. The hadith is mentioned that our Shaykh al-Rahut rahimahullah mentioned al-isnad hu da'f fi inqita'. That the isnad that is mentioned here regarding that view, that the isnad fihi da'f. It is weakness in the isnad. Aywa.
The hadith signifies that a disbeliever is entitled to inherit from a Muslim if the former converts to Islam before the estate of the Muslim deceased is divided.
Aywa.
The fourth opinion, the Muslim inherits from the disbeliever and not vice versa due to the hadith, Islam increases and never decreases.
So also that hadith they mention al-Islam yazid wala yanqus. Also they mention that actually Abu Dawood or Shu'aib al-Nahud mention also all that isnaduhu da'if li-ibham alladhi haddatha Abu Aswad, based upon ibham of not one of the unknown, one of the narrators is criticized for not being known. So also this isnad they mentioned min al-ulama or da'af al-isnad or al-hadith to be da'if, and they mentioned also this hadith is somewhat general. As for the discussions, the hadith is general regarding Islam, it's but as for what is being discussed is something specific, so this hadith cannot be used in this specific case, as the hadith here is very general and non-specific. And we're discussing a specific matter.
This is because when the Muslim inherits from the disbeliever, that is considered an increase and not vice versa. The hadith signifies that Islam leads to increase, not to decrease. The preponderant view, and Allah knows best, is the first one, i.e. the Muslim never inherits from the disbeliever and vice versa, due to its sound and explicit proof, unlike those of the other views, which are weak and inexplicit proofs. Second, inheritance.
So that's so the Shaykh Hafidullah or mentioned regarding al-Raja', meaning concerning that with all its aqwal. So there's 4 aqwal between the ulama on this matter. That the Shaykh had mentioned the qawl, which is al-Raja', the more correct view on this is based upon the first view, based upon one that the evidence for it is somewhat very explicit and very clear and straightforward. So regarding la yarith al-Muslim al-Kafir wa la Kafir al-Muslim. So the hadith is very authentic. So the hadith muttafaqun alayh in the Bukhari and Muslim. As for the other aqwal that are mentioned, the 3 other aqwal, that the evidence that are used are somewhat the evidence that it is not strong. So the evidence by way of the hadith that they use are not very strong and clear on the discussion. So precedent is given to the first view that clearly states that the Muslim does not inherit from the kafir, nor vice versa. Aywa.
Second, inheritance among disbelievers. As far as inheritance is concerned, disbelievers are divided into 2 states. First state, it is indisputable that disbelievers of the same religion inherit from one another, e.g. Jews from another Jew and Christian from another Christian.
So the next of those masail regarding concerning ikhtilaf al-deen. So he discussed first regarding Muslim wal kuffar. Now the next scenario, cases regarding kuffar between themselves. So between the kuffar and their religion they follow, that you find they have multiple religions. So you have Yahud, wal Nasara, Majus, al-Mulhid, Boozi, and many other things that are out there. Now, even some people worship even shaitan. You have even people that even worship shaitan in an organized fashion. So you have all those religions that they follow, but they are all classed as kufr, even though level of kufr some are even worse than others. But overall, regarding concerning, are they classed to being as one, where they can, because they are all kuffar in general, that they can inherit between themselves, because compared to Islam, they are kufr. But looking per se at those religions, each of them individually, that each of them represent a different religion. So based upon this, the ulama are khilaf, that as they will say that, as the Shaykh will discuss concerning that the mahal and nisa, he will mention regarding the area of difference between the ulama regarding this discussion, why there's a difference. He'll mention the reason. Aywa.
Second state, scholars maintain 3 different views concerning disbelievers of various religions, e.g. Jews, Christians, Magi, or pagans, whether they inherit from one another or not, in regard to determining whether disbelief involves one or several religions. First view, the Hanafi and Shafi'i schools maintain that disbelief...
So we mentioned regarding Mahal al-Khilaf, so what they discuss between the ulama and the fuqaha, at times when you have difference between the ulama, to look at, they say, try to identify what is referred to as mahall al-khilaf. What's the point that they differ on? What's the reason for their difference? So I mentioned regarding concern that, so kufr is seen as, is kufr millatin wahid or millatul muta'addida. So is kufr said to be one actually religion, even though they may have difference between themselves, and that's said that in opposition to Islam? Yes, that's the case. So if we put kufr and Islam, then kufr in whatever face or shape or form that they are said with Islam to be one religion. They're all non-Muslim. So yes, they are one religion if compared with Islam, but if compared between themselves, then they have adyan muta'addida. They have different religion between themselves and different sort of ways of the Jew, the Christian, the Majus, the Buzi, the Mulhid, and whatever else. They all have different practice as to what represent their religion. Aywa.
Involves one religion, i.e. all the disbelievers are of the same state. This is also one of the opinions adopted in the Hanbali school. Moreover, this is the opinion of the majority of scholars that disbelief, including all its creeds, is regarded as one religion. Thus, disbelievers inherit from one another regardless of difference in religion. This is because the legal texts with regard are general, so they are not to be restricted unless by the lawgiver. To illustrate, Allah exalted be He says, and those who disbelieved are allies of one another. Surah Al-Anfal, ayat 73.
That's the first opinion regarding they see al-kufr millatun wahid, that they see that kufr is one religion regardless of the difference between themselves. So the first opinion, take that the kufr is one religion in whatever form or shape that they may represent their religion. So based upon this, that they can inherit between themselves. They can inherit between themselves. So a Jew can inherit from a Nasara, a Buzi, a Mulhid, because they are kufr in one that represent one thing, disbelief of Islam. And he was that's concerning one of the opinion, and he mentioned وَقَوْلَ الْحَنَفِي وَالشَّافِعِيَّةِ. Aywa.
Second view, disbelief comprises three religions, Judaism, Christianity, and the other types as one religion, as they have no sacred book. Thus, a Jew is not to inherit from a Christian, and both of them are not to inherit from a pagan, and so on.
So the second view is that they make a distinction regarding concerning kufr, that they divide them into three categories. Concerning the religion adyan al-kufriya, that they divide them into three religions, al-Yahud wa Nasara, based upon the Yahud and Nasara, that they were giving a book. As for and then the third religion would be others outside these two. So you have Yahud, Nasara, and others outside these two. Then, so based upon that, they can make a distinction. So in that view, they can somewhat also, their outcome is that they do not inherit between themselves. So you have either the people of the book and the people who are not given a book, but they have their own religion. So Al-Buzi, Mulhid, Al-Awthan, Ubad al-Awthan, that they are said to be of those people without a book. They have no per se book, so they are considered to be all in one category. Then you have category of Yahud and Nasara. So they said the outcome with them, they do not inherit between themselves. Aywa.
Third view, disbelief comprises several creeds. People of each are not to inherit from those of others. To illustrate, the Prophet ﷺ says, people of two different religions cannot inherit from one another. Related by Ahmed, Abu Dawud, and Nisa'i, and Ibn Majah.
And min al-ulama, they mentioned Sheikh Ibn Hud, that all the hadith to be Hassan, and also before him, Ibn Abdul Hadi. So Ibn Abdul Hadi, one of the ulama of the Hanabila, also the hadith to be Jawli Isnadu, that all the isnad to be good. So they mentioned that لا يتوارد أهل الملتين شتى. That the third opinion is that regarding al-kufr, that they have many religions. They have many religions between themselves. So Yahudi wa Nasara, Buzi, all are said to be a separate religion, and based upon this, that they do not inherit between themselves. They do not inherit between themselves.
According to the aforementioned hadith, the third view seems to be the preponderant one. That is, people of different religions, e.g. Muslims and disbelievers, are not to inherit from one another due to the lack of mutual support among them, and also because the cause for inheritance is this case contradicts the cause impending inheritance. In other words, difference in religion entails conflict in all other matters, and this leads to the disinheritance from one another. The scholars who viewed that this belief involves one religion consider that the difference of location, i.e. living in two different states, is a disinheriting factor due to the lack of mutual support among them, which is applicable when there is difference in religion. Thus, it seems more appropriate that the people of the different religions, a Christian and his Jewish relative, for example, cannot inherit from one another. However, disbelievers of the same religion can inherit from one another, and Allah knows best.
And that's concerning that. So that's the outcome regarding other than Islam. So the religion other than Islam, regarding that's between themselves. So that's the matter. Those matters may come into play in a Muslim society, that you have non-Muslim living in a Muslim society, and the matter is put to a judge. So what's the rule regarding so? But that's between themselves. Aywa.
Bismillah wa salatu
one more chapter.
ala rasulillahi qala alif hafidhullah, chapter 25, page number 343, title Inheritance of the Murderer of the Inherited Person.
Hey, so of those, the third of those masalah to be discussed regarding inheritance, where they said of those things of mawana, of a reason, a factor that may block a person from inheriting from another. And of those cases, they mention al-qital. So if one was to murder or kill a family member, then that can block him from inheriting from that person. So that would be the next discussion. Aywa.
Causes of inheritance may exist, yet an entitled heir may not be given her prescribed share. There are many causes that prevent one from receiving one's share of estate. One of these causes is the case of an heir who murders the inherited person. To illustrate, the Prophet ﷺ says, no share of the inheritance of the murdered person is to be given to the murderer. The Prophet ﷺ also says, a murderer is not to inherit anything from the inheritance of the person he killed. This mainly aims at blocking means to committing what is prohibited, as love for wealth might drive an heir to murder whom he may inherit. The well-known rule states, whoever hastens to possess something before its due time will be punished by not having it. Scholars unanimously agree.
So the hadith that they discussed regarding concerning ليس القاتل ميراث ولا يرث القاتل شيء. So those hadith that are mentioned, that they mentioned hadith in the Abu Dawood and others, that there's some discussion regarding the hadith. So you find those hadith that some discussion. So you find the likes of Ibn Hajar rahimahullah that he mentioned regarding concerning the hadith. You find that some discussion between the ulama regarding the hadith that mention this matter or discuss this topic. So you find that Ad-Daraqutni, or you find that the hadith in Ad-Daraqutni when and others, they mentioned Ibn Abdul Barr rahimahullah. So Ibn Abdul Barr, that all the hadith to be qawi, regarding that the hadith is authentic. Then you find others of them Nasa'i, that all the hadith to be mawquf. Say all the hadith to be the statement of the Sahabi, that not per se the statement of the Prophet ﷺ. And you have others who have somewhat, and regarding some of the narrators in the hadith, that Bukhari rahimullah have discussed some of the narrators in the hadith, or criticized some of the ruwat in the hadith. So you find some of the narrators in the hadith also criticized by some of the ulama, but you have a back and forth between the ulama, or a discussion between the ulama on on this hadith being authentic. Those who hold the hadith to be somewhat strong, suitable for to be used as a proof, and others that hold the hadith not to be suitable to use as a proof. Aywa.
Scholars unanimously agree that the murderer of the inherited person is to be disinherited. Yet they maintain different views with regard to the type of murder that prevents one from inheritance.
So Apostle mentioned regarding, so if one was to take the position that the hadith that discuss this matter are somewhat daif, then the evidence to say that a person does not inheritance would be al-ijma. So ijma, so the person was to come to the conclusion that a hadith, those are the hadith, as we mentioned before, is on a discussion between the ulama of hadith. But if the person was to take the position that a hadith is weak, then the thing that will be used as an evidence, the proof to say that person does not inherit, a murderer or a killer does not inherit from a family member, would be al-ijma. Would be the next level of Islamic proof, which would be al-ijma, a consensus of the ulama. A consensus of the ulama that such a person who does such an act then is barred from inheriting from the person that he killed as a family member. Aywa.
According to Imam Shafi'i, may Allah have mercy on him, the murderer never inherits anything, no matter what type of murder it is. This is due to the generality of the hadith of the Prophet ﷺ, in which he says, a murderer is not to inherit anything from the inheritance of the person he killed. This signifies that the murderer is not entitled to inherit from his victim in order not to let killing be a means to hasten obtaining inheritance. Consequently, whoever has a hand in the killing is to be disinherited, even if rightful. For example, the one who executes the qisas, legal retribution, the person who gives the judgment of killing, such as the judge, the witness in a murder case, all are all to be disinherited. This is applicable even if the act of killing is unintentionally committed, such as a killing done by one who was asleep, insane, or a child. Besides, this rule is to be applied in case the killing mistakenly results from a permissible act, such as the case of a discipliner or the physician who helps the person in treatment.
So Imam Shafi'i rahimahullah can somewhat take a very stern view on this matter, where his view concerned that the person who kills that person, anyone involved or attached, then you're not to inherit. So he mentioned that even the case concerned the person, others involved with, he mentioned that, so even for example, the person who his job is the carriage concerning the Islamic ruling, punishment. Sheikh, tafaddal. Then I'll come back. So Bismillah. So as we were saying regarding that of the opinion of this this matter, that Imam Shafi'i rahimahullah that take a very stern opinion on this matter, where anyone involved, then they are not to inherit. So even that person that so if the person who did the killing, as we'll discuss, so in Islamic law that they have categorized regarding a case of killing into different categories. They mention amd, the person did intentionally. Nam, shibl amd, the person that somewhat, and we discussed, and they have al-khata. So you have the person did intentionally, the person that somewhat or willfully, semi-willfully, and then you have third, khata, it was done by an error. That meant in all those cases, if you're involved, you're not in inheritance. Even to the extent that the person who carry out the hukum, that to take another person, that by the ruling that had been passed, that a person who carry out the killing, then also if you was to kill a family member, you don't inherit. Even though what you're doing, that is just passing out that judgment. So you said in all those cases, you are not allowed to inherit. You are not allowed. Even the case regarding, that as we mentioned, if a person's a doctor and he has a family member that he's doing a surgery on and you were to die, then you don't inherit. So if you're a doctor and you're carrying out a surgery on a person who's a family member, your parents, for example, are a family member, and that person was to die in that operation, then you don't inherit. Even though it was So for him, in all circumstance, there's no inheritance, which is a bit more stern position. So that's one of the opinion of the ulama. Aywa.
Followers of the school of Imam Ahmed viewed that the unrightful killing is the only kind that disinherits the killer. Unrightful killing is that which entails a legal liability such as qisas, legal retribution, diya, blood money, or expiation such as the premeditated murder, quasi-premeditated murder, and accidental homicide. This is also applicable with regard to what resembles accidental homicide, such as being the cause of killing or the killing committed by a child, an insane person, or a sleeping person. In contrast to this, if the type of killing does not entail qisas, diya, or expiation, then it does not cause one to be disinherited. To illustrate, killing someone as in qisas or in self-defense does not entail blocking one from inheritance. This is also to be applied in case the killer is a just person, whereas the murdered person is an oppressor of the killer, and also in case the killing results from a permissible act, such as disciplining or curing.
So the second opinion of Imam of the Hanabila regarding this matter is that they hold that the person is barred or blocked from inheriting in case concerned that the person did it intentionally. So the person intentionally went out to kill that person, then in that case he does not inherit. Now, so the ulama, they kind of somewhat in the bab of qisas wal hudud, that they kind of somewhat they see concern that says al-qital amd, where either the person intend to kill and he use a weapon that ordinarily will bring about death. So the person, meaning if a person, use a weapon that, so the person the intention, and also use a weapon that kills, or he didn't even so if he was to shoot a person with a gun, then that automatically considered to be armed, because ordinarily that when you use a gun it kills, or a person use a cutlass, a sword, and to hit someone, then in that case, if you were to claim that I didn't do it intentionally, it's considered to be intentional, because that weapon normally it kills. But so I said khata, a murder by way of error, that the person got into a fight with someone and you punched him and he fell and he dropped and he died. So I said ordinarily punching a person doesn't what? Kill. So depending on the you understand, so I said no, so that case may be looked as khata. So those things varies regarding concerning. So with the Hanabila, they see it as those cases where of amd, those are the only cases where a person is blocked from inheriting from the person. So done by way of khata and error, then you still inherit. Or the person who, as we said before, that the person is a doctor, is performing surgery on a family member, and that family member died in that surgery, then you still inherit, because your intention wasn't to harm the person, but it just happened that the person died, so you are not barred from inheriting from that person in those cases. As with the Hanabila, only the cases of the person intentionally, or the word they use over there, the word they use now today concerning intention killing.
Intentional.
Willful, premeditated killing. In those cases, you're barred. You're not allowed to inherit. Aywa.
What is mentioned above is also the view of the Hanafi school, whose followers consider being a cause of killing does not cause one to be disinherited, as in cases when one digs a well or puts a stone in, accidentally causing their inherited person to die. This is also applicable in case of accidental homicide or killing by a child or an insane person. According to the Maliki school, a murderer has two states. First case, when a murderer intentionally kills the inherited person. In such a case, the murderer is not to inherit either from the estate of the murdered or the diya, blood money. Second case, when one accidentally kills the inherited person. In such a case, one is to inherit from the murdered person's estate, but not from the diya. This is because in such a case the killer does not intend to kill the inherited person, yet it is obligatory upon him, the killer, to pay the diya, so he cannot inherit from something he is obliged to pay. On reviewing the aforesaid opinions, the preponderant one seems to be that the kind of killing that disinherits one is that which entails a legal liability, while the accidental homicide does not inherit one, as maintained by the Hanbali and Hanafi schools. This is because in case murder entails a legal liability, the killer is not accused and must bear the responsibility. Thus, he is to be disinherited. However, in case killing does not entail a legal liability, the killer is excused and is not responsible for it. Thus, he is not to be disinherited. If we are to follow the opinion adopted by the followers of Imam Shafi'i, which states that any type of murder prevents the heir, the killer in such cases, from inheritance, this will prevent executing the prescribed punishments. According to what is mentioned above, the generality of the Prophet's hadith, no share of the inheritance of the murdered person is to be given to the murderer, is restricted only to the case of killing unrightfully, which does not entail a legal liability. Allah exalted be, He knows best.
That's the end?
That's the end.
Yes, that concerns the conclusion of the general chapter regarding al-mirath. So matters regarding mirath or fara'id, bab al-fara'id. Then we have covered concerning or ended that discussion regarding of those masail or those matters that are generally discussed in this discussion. So with that, inshallah ta'ala, we'll be going now to the next bab regarding kitab al-nikah. So in the next lesson, we'll be starting a new chapter regarding this. So we'll be discussing concerning bab al-nikah, that would be bab al-nikah, talaq, and all the things that are involved regarding those things. They are referred to as concerning that ahkam al-usra. So matters regarding ahkam al-usra, discussing regarding family matter that relates to family life. So family life regarding those things of nikah, the rules of nikah, divorce, al-khula, matters regarding al-lan. So all those things will be discussed in the next within that discussion regarding ahkam al-usra.